"Stop right there, officer. Don't read another line." That was the first thing I said, and when I said it, the room snapped tight. The prosecutor had a file open in front of him. The arresting officer was halfway through his direct testimony. The defendant stood at counsel table, with both hands flat against the wood, shoulders square, jaw locked so hard I could see the muscle jumping from the bench, and I was no longer listening to the words coming out of that officer's mouth because I had already seen the one thing in that courtroom that mattered. His face, not the officer's, the defendant's. 3 years earlier, that same man had stood in front of me on a drug possession case that should never have been brought. I remembered him because innocent people do not all look innocent, but they do carry a certain silence when the machine has rolled over them once already. I remembered the silence. I remembered the stare. I remembered acquitting him because the state's evidence had bent in my hands like wet paper. Now he was back. Different file, different caption, different last name, same man. The prosecutor looked up at me, annoyed before he was cautious. "Your Honor?" I leaned forward. "State your name for the record," the defendant answered without taking his eyes off me. "Daniel Morales." I picked up the older memory before I picked up the new file. "Have you ever stood in front of me before?" His lawyer shifted. The prosecutor cut in immediately. "Objection. Relevance." I did not look at him. "I didn't ask you." The defendant took one breath. "Yes, Your Honor." "Under what name?" He swallowed once. "Daniel Vega." The courtroom did what courtrooms do when truth enters uninvited. Nobody moved. Nobody spoke. But every person in that room started listening harder. The prosecutor tried to recover the ground he felt slipping. "Your Honor, many people use different surnames. We're here on a new charge." "Yes," I said. "That is exactly what concerns me." I turned to the clerk. "Pull the file from 3 years ago. Drug possession, defendant Daniel Vega. I want it brought up now." The prosecutor stood. "This is highly irregular." "No," I said. "What's highly irregular is that I remember a wrongful possession case with a face I do not forget, and that face is back in my courtroom under another name. Sit down." He sat, but not because he wanted to. He sat because there are moments in court when everyone understands the floor is shifting and the safest lie is silence. The officer on the stand adjusted in his seat and looked toward the prosecutor for help. That told me something too. I looked at him. "What precinct?" He blinked. "Your Honor?" "What precinct are you assigned to?" The prosecutor was on his feet again. "Objection. This line of questioning goes beyond—" "Answer the question." The officer cleared his throat. "Ninth Precinct." There it was, same precinct. I had not yet seen the lab report. I had not yet seen the chain of custody form. I had not yet heard the stop explained. But already the edges of the old case were sliding under the new one like a blade under a locked door. If you've ever watched a room realize that the judge is no longer deciding whether a witness is credible, but whether the whole architecture around him is rotten, then you know what happened next. People didn't breathe the same way. The prosecutor tried to push forward before the old file could arrive. "Your Honor, the people are prepared to establish possession of narcotics recovered from the defendant's backpack during a lawful stop." The defendant's hands tightened against the table. I asked, "His backpack?" "Yes," I said. "That phrase sounds familiar." The prosecutor answered too fast. "Because possession cases often involve containers." I let that sit there for a second. "And false cases often involve language copied from other false cases." He did not like that. "Your Honor, with respect, that is an extraordinary statement." "No," I said. "An extraordinary statement is what I'm waiting to hear from your officer." Then I turned back to the witness. "Describe the stop." The officer straightened and gave me what officers give judges when they think routine phrasing can do the work of truth. The defendant was observed in a high narcotics area engaging in suspicious behavior. Upon noticing police presence, he clutched a dark backpack, changed direction abruptly, and made what appeared to be a furtive movement near a parked vehicle. The defendant gave one dry laugh through his nose. His lawyer put a hand on his sleeve. "Don't." I said nothing for a moment. I had heard those words before. Not just the ideas, the words. High narcotics area, suspicious behavior, change direction abruptly, furtive movement. The old file had not even reached me yet, and I already knew where this was going. "Did you write that report yourself?" I asked. "Yes, Your Honor." "Word for word?" "Yes." The prosecutor looked pleased. That bothered me. Men only get pleased that early when they think the script will hold. Then the clerk stepped up and placed the old file on my bench. I opened it. The prosecutor stood the instant I did. Your Honor, I object to consulting materials outside the evidence in the pending matter. I looked down at the older police report. Observed in a high narcotics area. Changed direction abruptly. Furtive movement near a parked vehicle. Dark backpack. I closed the file slowly. Counsel, I said, if I laid these two reports on an overhead projector, your officer might sue one of them for plagiarism. The defense lawyer almost smiled. The prosecutor did not. He tried another move. Even if there are similarities in language, that has no bearing on whether narcotics were recovered in this case. No bearing. That phrase. Lawyers use it when they want to amputate the cause from the consequence. I asked the officer who recovered the alleged narcotics. I did. Who vouchered them? Property intake processed the evidence. Name. He hesitated. That was important. Name, officer. Sergeant Kelleher. I looked at the old file. Same chain of custody officer. The prosecutor saw me see it. Your Honor, I held up a hand and he stopped because he had finally understood something was beginning to collapse that he could not hold up with volume. Which lab analyzed the substance? He answered because the officer could not. Metro Forensics. I opened the old file again. Same lab. I looked at the defendant. He did not nod. He did not plead. He did not do anything theatrical. He just stood there like a man, hearing an old trap close from far enough away, this time to finally recognize the sound. That mattered to me more than any performance ever could. The prosecutor tried to regain control. Your Honor, the people can prove the substance tested positive. We have a certified lab report and the arresting officer's testimony. This is straightforward. Straightforward, I said, is not the same as clean. He bristled. The defense has not alleged misconduct. That was when the defendant spoke. Because every time we do, they arrest somebody else. His lawyer grabbed his sleeve again. Daniel. No, he said, still staring at me. No, let me say it plain. The prosecutor pounced. Move to strike. Denied, I said. He has opened a door. I intend to see what's behind it. The prosecutor's voice sharpened. This is becoming a political hearing. No, I said. It may be becoming an honest one. I asked the defendant's lawyer, are you asserting targeted enforcement? The lawyer looked at his client, then back at me. He knew the risk. Once you say those words in open court, every institution in the room stiffens. Yes, Your Honor, we are. The prosecutor actually laughed. Not loudly, just enough to disrespect the idea. I do not forget that sound either. On what basis? I asked. The lawyer reached into his briefcase and pulled out a thin folder that looked too light to carry what he hoped it carried. My client is a community organizer. He has publicly criticized stop and frisk practices in the Ninth Precinct. He filed 2 formal complaints in the last 2 years. The prosecutor snapped. Irrelevant. The defense lawyer kept going because he knew if he stopped, he would lose the air in the room. After the first complaint, he was arrested on the old possession case and acquitted. After the second complaint, objection. He was arrested again. The prosecutor turned toward me. We are not putting the police department on trial. I said, that depends on what the facts do next. Then I looked at the defendant. Did you file complaints? Yes. Against whom? He answered carefully. Against officers from the Ninth. 1 for an unlawful stop outside our office. 1 for detaining teenagers during a canvass. Your office? We organize tenants, families, people stopped on the street. We document patterns. We help them file complaints. That was the second layer, and it did not arrive quietly. It arrived with resistance, exactly the way truth usually does, in a courtroom built to handle isolated incidents and not patterns. The prosecutor stepped toward the bench. Your Honor, may we approach? No, say it where everyone can hear you. His jaw tightened. This line of inquiry is prejudicial, inflammatory, and unsupported. I said, bring me support then, or sit down while the defense does. He sat, but now he was angry enough to get careless. That helped. I turned back to the officer. Were you aware the defendant had filed formal complaints against your precinct? No, Your Honor. Too fast. Were you aware of his organizational work? No. Too flat. Had you ever seen him before the arrest? No. The defendant looked down and shook his head once. I asked, what? The prosecutor barked. Your Honor, I ignored him. Mr. Morales, answer my question. He lifted his head. He was in the room when I filed the second complaint. The prosecutor almost shouted. Self-serving. The officer snapped toward the defense table. That's false. There it was, chaos, not because truth had emerged, because the moment it did, people lunged to crush it. I raised my voice just enough to stop the room. Nobody speaks unless I tell them to. Silence again. Then I said to the officer, "Did you hear him?" "Yes." "Did you say that was false under oath?" "Yes." "Good," I said, "because now it matters." I asked the defense lawyer if he had documentation of the complaints. He said he did. The prosecutor objected before the papers even touched the rail. "Foundation, then lay it," I said. The defense lawyer handed up copies. Stamped intake forms, dates, internal complaint numbers, one acknowledgement letter on department letterhead. I read every line while the courtroom waited. The dates sat there like nails. First complaint, 16 days later, old arrest. Second complaint, 12 days later, new arrest. That by itself was not proof. Timing can be coincidence. Courts must not become rumor mills with gavels. I have spent too many years on the bench to confuse suspicion with evidence, but suspicion is where a careful judge starts, not where he stops. I looked at the officer again. "You had never seen this man before?" "No, Your Honor." I held up the second complaint acknowledgement. "Your badge number appears in the narrative attachment." The prosecutor objected so fast the word broke in half. "Objet, sit down." The officer's face changed a fraction. "It was enough," I said. "Let me ask more simply. Did you know who he was when you stopped him?" The officer swallowed. "I knew of him." The defendant's lawyer closed his eyes for half a second. Not in relief, in recognition. A small difference, but a real one. The prosecutor rushed in to limit the damage. "Knowing of a community member does not invalidate a lawful arrest." "No," I said. "But lying about knowing him does damage a witness." Then I asked the question that pulled the room another inch toward the edge. "Who else from his organization has been arrested by the Ninth Precinct in the last 18 months? The prosecutor stood so quickly his chair scraped. "Absolutely not. This is beyond the scope. This is a fishing expedition." The defense lawyer answered before I could. 5 others. The room turned again. "Names," I said. The prosecutor slammed a hand on counsel table. "This is outrageous." I looked at him. "Counsel, if your objection needs furniture to support it, it may not be a strong one." He stopped touching the table. The defense lawyer opened the thin folder and pulled out another sheet. Not a dramatic gesture, just paper. Most destruction in court begins with ordinary paper. 5 members of the same organization, he said. All arrested by officers from the Ninth. All misdemeanor or violation level charges. Disorderly conduct, obstruction, trespass, open container. All within 18 months of filing or assisting with formal complaints. The prosecutor said, allegedly. The lawyer answered, with docket numbers. He handed them up. Now listen to me carefully, because this is where a weak script would rush. A real courtroom does not burst into music when the pattern appears. It gets uglier. The stronger the pattern, the harder people fight to reduce it to coincidence before it hardens into record. The prosecutor asked for a recess. I denied it. He asked for the documents to be stricken. Denied. He asked that the matter be limited strictly to the stop and recovery. Denied. He asked to proceed by stipulation on the lab and chain of custody. Denied. Every door he tried to close only told me what was behind it was worth looking at. That is when he made the move I had been waiting for. Your Honor, he said, voice suddenly smooth. In the interest of justice, the people moved to dismiss. There it was. Not when the defendant first challenged the stop. Not when the old case surfaced. Not when the complaints came in. Right now. Right when the pattern threatened to become visible on the record. The defense lawyer said, no. The prosecutor turned on him. You don't oppose a dismissal. I oppose being buried without findings, the lawyer said. I looked at the prosecutor. You are moving to dismiss because you cannot meet your burden. We are exercising discretion. No, I said. You are running from a transcript. He stiffened. The people have broad authority. And I have eyes. The courtroom went dead still. I had to be careful there. Very careful. Judges do not get to punish motives. We judge records. We decide cases, not vendettas. But when a party tries to terminate a prosecution the moment its structure begins to reveal abuse, a judge does not have to pretend not to notice. I said, motion held in abeyance. We continue. The prosecutor was furious now. Good. Anger makes clever men repeat themselves. I called for the chain of custody officer, Sergeant Kelleher. The prosecutor objected that he was unavailable. Then produced the property record and the person who signed it. He said the certified documents should suffice. Not today. The defense lawyer added, Your Honor, we also request the lab bench notes. The prosecutor nearly laughed again. On a street-level possession case? I answered for him. especially on a street-level possession case. You want to know when the room understood this was no longer a routine hearing? It was when court officers started closing the side door because people in the hallway were leaning in. That is how pressure looks in a courthouse. Not explosions, doors closing, whispering stopping, pens moving faster. We took a brief recess while the clerk located the property records. When we returned, Sergeant Kelleher was in the building. Funny how unavailable witnesses become available when the bench stops indulging performance. He took the stand. I asked him, "Did you receive evidence in the case of Daniel Morales?" "Yes." "Did you receive evidence in the case of Daniel Vega 3 years earlier?" He looked toward the prosecutor. That was answer enough, but I made him give me the spoken version. "Yes." "Did you notice any similarity in packaging?" "I processed many items." "Not my question." He shifted. "I don't recall." The defense lawyer handed up photographs from Discovery. Small plastic twists. Same color ties. Same marker notation on the evidence bag. Same initials in the corner. Kelleher said, "Standard packaging varies." The prosecutor said, "There's nothing unusual about narcotics packaging." The defense lawyer said, "There is when the same bag appears in 2 different stories." The prosecutor wheeled around. "That is argumentative." "It's accurate," I said. Then came the next fracture. The property log showed the evidence in the present case was booked at 9:42 p.m. The arrest report placed the recovery at 10:15 p.m. 43 minutes later. The prosecutor tried to explain immediately. "A clerical error." I looked at Kelleher. "Did you sign for evidence before it was allegedly recovered?" "No." "Then which document is false?" He did not answer. I asked again. "Which document is false?" The prosecutor jumped in. "Your Honor, isolated timing discrepancies are not uncommon. Among honest records," I said, "they are corrected. Among dishonest ones, they are defended." The defendant had not moved through any of this. He stood there listening like a man who had spent years being told the system only cared about his posture when it wanted to punish him for it. Then the defense lawyer asked to recall the arresting officer. The prosecutor objected. Overruled. The officer returned to the stand already irritated, which is the wrong condition for a witness who has started losing altitude. The defense lawyer placed the complaint acknowledgement in front of him. "You were present for this complaint interview, correct?" "No." "Your badge number is on the attachment." "I may have been referenced." "Were you in the room?" "No." The lawyer slid over building security footage stills obtained by subpoena. Grainy, date stamped. Complaint office corridor. The officer in the image was him. The prosecutor was on his feet before the still had even settled on the evidence rail. "Foundation, authentication. We need voir dire." "Of course you do," I said. "Sit down, you'll get it." We authenticated the footage. Building security supervisor. Timestamp protocol. Chain. It held. Then I looked at the still again and asked the officer one final time. "Were you in that room?" A long pause. "Yes." The prosecutor closed his eyes. The defense lawyer did not smile. Good lawyers do not celebrate in the middle of a live fire. I asked, "So when you testified that you had never seen him before, that was false?" The officer tried the oldest trick in court. He changed the category. "I didn't know him personally." "That was not your answer." Silence. "That was false?" "Yes." I looked at the prosecutor. "Do you wish to continue?" He said yes. That surprised some people. It did not surprise me. Institutions in retreat often become most dangerous when they decide they have too much pride to stop. The defense called the defendant. "Now understand this. I did not know if he was a perfect man. Courts are full of imperfect people telling the truth and polished people lying under oath. My job was not to certify his sainthood. My job was to measure the evidence against the state's burden." He testified that he had left an organizing meeting and was stopped half a block from the office. He said the backpack the officer described was not his. He said when he asked why he was being stopped, one officer answered, "You like paperwork, right? Here's some more." The prosecutor objected, overruled. He testified that 5 members of the organization had been arrested after complaint activity. The prosecutor objected again, overruled. He testified that fundraising dropped after his first arrest. Tenants got scared after his second, and one landlord's attorney had used his mugshot in housing court to attack his credibility. The prosecutor objected as prejudicial. I let that in too, because that was the point, wasn't it? Not just to arrest him, to dirty him, to make every room after the arrest remember the accusation longer than the acquittal. If you're still with me, stay with me now, because this is where the case stopped being about one man and started behaving like a map. The defense lawyer offered a chart. Dates of complaints, dates of arrests, names, charges, same precinct, same cluster of officers appearing over and over, minor cases, pleas in some, dismissals in some, one acquittal already sitting in my own memory under another surname. The prosecutor objected to the chart. I admitted it for limited purpose. He moved for mistrial, denied. He renewed his motion to dismiss, denied. He asked that any findings be narrowly confined. I said, my findings will be confined to the truth the record permits. That was when I knew what I would eventually write, though I had not yet decided how much of it the public would be ready to hear. The lab notes came up just before the afternoon session ended. The substance weights did not match, not by a lot. Enough. The prosecutor said the variance resulted from moisture loss. The defense pointed out the tested weight was higher, not lower. The prosecutor said the difference was negligible. The defense asked why the bench notes referenced a seal number not matching the voucher. The prosecutor had no clean answer. He asked for overnight adjournment. I granted it, not for his comfort, for the record. That night I took both files home in my head, not in my hands. Judges don't get to investigate from the kitchen table. We work with what enters the courtroom. But I knew by then that what had entered my courtroom was not random. The next morning, the prosecutor came in with a softer face and a harder plan. He tried to narrow the case to probable possession, arguing constructive control, proximity, officer experience, field test, certified report, administrative inconsistencies. He spoke for a long time. That is another thing people do when the facts are deserting them. They try to replace evidence with duration. When he finished, I asked only one question. Can you tell me, with a straight face, and on this record, that this prosecution was untouched by the defendant's complaint activity? He did not answer immediately. Then he said, the people reject the premise. Not yes, not no. Reject the premise. I wrote that down. The defense lawyer's closing was shorter. Smart man. He did not try to turn me into a political ally. He kept bringing me back to the same place. False denial, same precinct, same chain officer, same lab, impossible timestamp, alternate surname that prevented the system from easily seeing the first acquittal, and 5 other complaint-connected arrests circling the same organization like vultures that had learned a route. Then the defendant asked if he could address the court. The prosecutor objected. I overruled him. The defendant said, I'm not asking you to believe I'm important. I'm asking you to notice I'm expensive to keep answering. That line landed harder than anything else that week. Not important, expensive. That is how neutralization works in systems that understand paperwork better than blood. You do not always have to convict a man to weaken him. You arrest him enough times, photograph him enough times, force him to borrow enough money, miss enough meetings, lose enough donors, scare enough neighbors, and eventually people stop saying his name with confidence. They start saying, I don't know, maybe there's something there. That sentence has ruined more innocent people than many verdicts ever did. I recessed for 40 minutes. When I returned, I delivered the ruling from the bench. I found the arresting officer not credible. I found the false testimony about prior contact deliberate. I found the chain of custody compromised. I found the documentary discrepancy significant and unexplained. I found the people had failed to establish lawful possession beyond a reasonable doubt. And I acquitted Daniel Morales. Not Vega, not Morales. Daniel. The same man the system had tried to split into 2 names so it could frame him twice without tripping over its own first lie. The prosecutor asked that my ruling go no further than the acquittal. I looked at him for a long second. Then I said, Counsel, acquittal ends the prosecution. It does not erase what this record has exposed. The defendant sat down slowly like his knees had only then remembered they existed. Most acquittals end there. A breath, a thank you, a file closed. But this one did not deserve to end quietly. And quiet endings are how patterns survive. So I did something judges sometimes forget we can do. I wrote 14 pages. Not rage, not slogans, facts, dates, docket numbers, complaint filings, arrest intervals, shared precinct, shared chain officer, repeated language in reports, false testimony, documentary inconsistency, limited findings where they had to be limited, explicit findings where the record permitted explicitness, and yes, I named the precinct. The prosecutor's office tried to narrow publication. Denied. They asked that references to non-party arrests be sealed. Denied, except for personal identifiers where law required protection. They argued my language would undermine public confidence. I wrote that public confidence is not preserved by concealing recurring misconduct. It is preserved by confronting it before cynicism hardens into lawlessness. I entered the opinion into the public record. And then the strangest thing happened. Lawyers read it. That should not sound strange, but trust me, most opinions die honorable, unread deaths. This one moved. A public defender sent it to a civil rights lawyer. A civil rights lawyer sent it to a law professor. A law professor put 2 paragraphs into a legal newsletter. Then another outlet quoted the section on administrative fragmentation of identity through alternate surnames. Another quoted the line about repetitive low-level prosecution as a mechanism of civic neutralization. Within days, people far outside my courtroom were saying the precinct's name out loud. Months later, I read that a federal civil rights investigation had been opened. I was not in those rooms. I did not direct it. Judges do not lead federal investigations because they wrote sharp opinions, but words, when placed carefully in a public record, can travel farther than a raised voice ever will. Subpoenas followed. Grand jury activity followed. Then came the indictments, federal charges against officers tied to fabricated reports, false statements, civil rights violations. Not everyone, not all at once. Real accountability almost never arrives in one cinematic sweep. It comes in filings, in interviews, in sealed motions, in men who once looked untouchable, hiring lawyers and walking past cameras without that old swagger. I saw Daniel once after that, outside the courthouse, not in a case, on the sidewalk. He was carrying folders, still working. He nodded. I nodded back. No speech. None was needed. That is the thing I want you to understand. A judge does not save a republic with volume. We do not fix corruption by sounding more dramatic than the people committing it. Most days power on the bench is narrow by design, and that is good. A judge who reaches beyond the record is a danger no matter how noble he imagines himself to be. But a judge who refuses to see a pattern because the pattern is inconvenient is a different kind of danger. People think the gavel is the weapon. Sometimes it is. Sometimes acquittal is. But sometimes the most severe act available to me is not a sentence, not a contempt finding, not a lecture delivered from above the seal. Sometimes it is a clear paragraph, a clean record. A fact written so plainly that everyone who touches the file afterward has to choose whether to face it or expose themselves running from it. That precinct did not fear my anger. Men like that rarely do. They fear durable language. They fear dates placed side by side. They fear a judge who does not decorate the truth because decoration gives cowards places to hide. And if you want to know why I still remember the first moment of that second case, it is not because of the officer or the prosecutor or even the contradiction between the 2 names on the 2 files. It is because when I asked that defendant whether he had ever stood in front of me before, he did not look surprised that I remembered him. He looked surprised that I was willing to say it out loud. That is a damning fact in itself. An innocent man had learned to expect institutions to forget him between harms. He had learned that memory belongs to the people doing the accusing, not the people doing the surviving. On that day, memory answered back, and the record did what records are supposed to do when honest people still have their hands on them. It refused to look away. I have said many things from the bench over the years. Some were stern, some merciful, some necessary. A few followed me home longer than they should have. But this is the one line from that matter people keep repeating. And I understand why, because by then the room was done performing. The evidence had finished arguing. The names were on paper. The pattern was no longer asking permission to exist. So I said what the moment required. Sometimes the most powerful thing I can do is write clearly and let the facts speak without mercy.